Well, ladies and gentlemen, welcome again, and welcome to this webinar and book launch of Electronic Evidence and Electronic Signatures, published by University of London Press in its 5th edition, edited by Stephen Mason and Daniel Seng. I'll just do a very quick introduction of the two editors, and then let them tell you a little bit more about the book. Mr. Stephen Mason is a visiting lecturer at the School of Law, University of Tartu, Estonia. He's also an associate research fellow at the Institute of Advanced Legal Studies, School of Advanced Study, University of London, and was a visiting professor at NUS Law. And my dear colleague, Associate Professor Daniel Seng, is the co-director with me of TRAIL, the Center for Technology, Robotics, Artificial Intelligence, and the Law. TRAIL is blazing the trail. He teaches and researches on information technology law, IP law, and evidence. I'll hand you over to Daniel to tell you a little bit more about the book and today's webinar. Over to you, Daniel.
Thank you so much, David. Can I confirm that my slides are online and everyone can see them?
Yes, good.
Yes, good. So I think to introduce all of us to the conference, I'll say a little bit about the topic of electronic evidence and how it is very often overlooked, but still remains extremely important in the cause of justice. And with that, after that, I will hand you over to our first speaker. So I think it is important for us to step back and contextualize the pervasiveness of electronic evidence. These are just some of the scenarios I've culled from some local cases in Singapore that have admitted these various forms of electronic evidence in legal proceedings. These range from instant messaging chat statements regarding conspiracies and e-commerce transactions to various forms of computer printouts that range from business registration records to databases, to bank dispatch systems, to Excel spreadsheets and ledgers and drug analysis reports, to even emails setting out correspondence, leases, and contents and the date timestamps. In fact, electronic evidence is so topical. My slide about how Alexa's recording system might be a key witness to a murder case has just been superseded by a report just this morning from CNN indicating that Amazon's Echo system, Echo's key camera system, had been used by the police to admit evidence of happenings around the neighborhood without the need for a subpoena. So a lot of interesting developments in the electronic evidence space are taking place all around the world. And electronic evidence is highly pervasive and runs through everything that we need to establish truth or cause of action, both in civil and in criminal proceedings. At the same time, we are seeing this escalation in the use and reliance on evidence generated by AI systems, for which Burkhard will say more about later. So some of us in Singapore will remember that during the COVID-19 saga, we had robocops, literally robots roaming the town centers, trying to catch smokers and COVID rule breakers. And our police cars are now equipped to scan license plates remotely for detection and identification purposes. One actually doesn't need to look far back to understand that developments in this space have not been very forthcoming until recently. In 1996, our Singapore Evidence Act had a very outdated mechanism in which we sought to admit computer output, which is the antiquated form of electronic evidence, via the 3 modes of admissibility. In 2003, a colleague of mine, Sriram Chakravarti, and myself co-authored a paper in which we recommended the introduction of a technology-neutral approach to the admission of electronic evidence in Singapore, with a view to simplifying the procedural mechanism for admitting electronic evidence. The thinking then was that this would enable courts to conduct an enlightened judicial assessment of electronic evidence to address the myriad of issues that arise from electronic evidence, which you'll hear more about from our speakers this morning, afternoon, or evening. In 2012, the government accepted our proposal, abolished 1996 provisions, and came up with the new approach that is currently in place in our law books today. as Mr. K. Shanmugam, the Minister for Law, explained, the rules providing for the relevancy, admissibility of evidence, including hearsay, best evidence rules, and rules of authentication, the existing common law regime will continue to regulate the admissibility of electronic evidence in the same manner as any other item of evidence. It is on that basis that Stephen and I decided that many years back, we should actually be looking at the handling or the treatment of electronic evidence with a little bit more care and concern, because it is every bit as important as the late Chief Justice Yong Ban Hao explained in this case, that a computer printout tendered should be reliable whether it is or it does not contain hearsay, among other things. And in the book and the various other pieces of writing, Steve and I explored issues about how complex electronic evidence can be, because even though the form of it may be electronic, the modality for analyzing its contents and its derivations and its application remain pretty much unchanged. So you will recall that we embarked on a series of writings in which we tried to explain that electronic evidence can take the form of hearsay or real evidence, or even a combination of both hearsay and real evidence. And these issues have actually not been thoroughly explored in many of our courts today. And this is where we think a piece of writing like the Electronic Evidence and Electronic Signatures book that Stephen and I have put together with the help of all our co-authors is very important. Just to give an example, which I just culled from Google, my premier source for information these days. This is a screen capture when I did a Google search on myself. Okay? So on the left-hand side, you see this screen capture that says Seng Daniel, researcher, explains my affiliation, my research interests, and the books that I've written. Unfortunately, the electronic evidence book is not listed there, only at the bottom here, and it's even a little bit outdated. But if you look at it very carefully, for those of you who know me, this is actually not me. Well, more accurately, this is not my photograph. The point that I want to make with a simple web capture like this is to tell you that even a piece of simple electronic evidence captured from the web can contain a mixture, an admixture of both real evidence, hearsay evidence, and hybrid evidence. And how does one go about sorting through real evidence from hearsay evidence? Which parts of this evidence are reliable and which parts of it are not? Because the way the Google system assembled this piece of information is obviously drawn from diverse sources. Other evidence issues that we wish to explore, we have explored in our book, include issues about competence, the qualifications and the trustworthiness of experts testifying as to electronic evidence, AI and verification, any kind of verification or proof or guarantee of some relevant property of a computer program that generated the evidence, the authentication of the evidence, whether it is accurate, reliable, whether the identity of the parties can be assured, whether the integrity of the evidence can be preserved. As you can see from this screen capture, there was a recent scandal involving a Malaysian politician who claimed that he was in a fake video clip involving allegedly him being in bed with a minister, as well as the other very topical issues that range from encryption, which is what happens when electronic evidence is encrypted, and how does one find workarounds to access the decrypted information, to proof of the evidence. Is there any way we can accredit or train the experts and validate the technologies for preserving the evidence, to this ever vexatious issue of the presumptions related to electronic evidence, which Stephen and I will talk about later, essentially dealing the issue or the trustworthiness or lack thereof of computer systems and the evidence generated therefrom. So this is a short bibliography of a lot of the writings that have gone into this space. As you can see, Stephen and I have been writing about this space since the other millennium, since the old millennium, and we continue in this day and age to grapple with the very same issues. But this time, hopefully, with the help of our cohort of very accomplished contributors and authors, we will be able to make much more headroom in the space and perhaps bring greater enlightenment and understanding of the issues to the legal profession and the legal community. So with that brief introduction, thank you very much for coming to this conference. If you're interested in getting a copy of the book, you'll find this QR code on the left-hand side very useful, and we'll make available the slides that we'll be using for this seminar using the QR code on the right-hand side. Stephen, do you have anything to add?
No, other than thank you very much for a great introduction, Daniel, and just briefly to say that in many ways, the first edition of the book in 2007 was probably about 20 years too late. And the real problem that we have now, frankly, editing my journal of digital evidence and electronic signature law review, is that people are still very parochial about this topic, not only in just looking at their own jurisdiction when they're submitting articles to journal, but also failing significantly to understand the importance of this topic. But that hopefully this session will help enormously. So thank you for you and David for hosting this event, and Joseph for organising the whole thing. Without further ado, perhaps I will hand over to David and get on with hearing what Lynne has to say.
Sure. Thank you, Stephen. The first speaker for today is Ms. Lynne Townley, who will be talking about competence, the importance of the issue of competence, or the competency of witnesses regarding the trustworthiness or not of digital data cannot be overstated. What approach, therefore, should courts take when scrutinizing the competency of witnesses in cases involving electronic evidence? In the interest of time, I will not go through the bio of the speakers. They're all in the handout. So over to you, Lynne.
Thank you, David, and good morning, everybody. And it just strikes me that this subject has got boundless possibilities for international work, and maybe the pointer that actually breaks down international barriers around rules of evidence and the law. It's absolutely mind-boggling where we can go with this, and things that we couldn't even do 2 years ago, we now take it for granted. So quite what the next decade will bring is absolutely mind-boggling. And the time for this book and for further editions couldn't be more needed. So in relation to competence, we're kind of here, we're talking about AI and the interface between AI and systems and humans. So things that Daniel was touching on is, you know, that we have electronic evidence everywhere now in civil and criminal cases. My background is essentially in criminal as a practitioner and a teacher, but I now sit myself in some civil jurisdictions. A new thing for me, but you know, the issues are the same across civil and criminal. And when we're talking about expert evidence and competence, it boils down to something that's actually quite a simple concept, but not quite so simple when lawyers get behind it. But the whole idea simply behind having an expert come in to interpret any kind of evidence is simply to enable better decision making, where that decision making has to be made by human beings. So in criminal, that tends to be whether the issues in question are outside the expertise of the judge and the jury, where there is a jury, you know, or if it's not a jury trial, the fact finder. And the same thing works across civil. So what we then see, and I've called this a double dilemma, or perhaps a double kind of a fallacy, is that we've got electronic evidence on the one hand, which is sometimes accorded an infallibility wrongly. And then at the same time, we have an expert giving evidence. And again, there's a lot of work around expert evidence, and experts can be given an undue weight by fact finders. So there's a double issue going on that we need to guard against. So when I first got involved looking at expert evidence and when it was necessary, mostly from the criminal context, I first wrote on experts, it was 20 years ago, back in 2004. Now, some of the issues have moved on and some of them depressingly haven't in the last 20 years. But if I could start from where we were at that stage with computers, and we didn't really have AI, or at least we didn't call it AI, but we were still thinking about computers as the clunky things, you know, on the desks, and CCTV, which is now ubiquitous everywhere all over the world, was very much in its infancy. But if I could say that in that book, on the things that experts were called to speak to in the criminal courts in particular, there was a very small 6 or 7 page chapter. I just looked it up the other day, and it was one of the smallest chapters that actually dealt with computer crime and how electronic evidence might play a part within criminal trials. And then in addition to that, there was a small chapter about the visual evidence and CCTV and how that potentially affected identification evidence and so on. But the rest of it had to do with other types of things like DNA, fingerprints, and so on and so forth. But what we've seen in the last 20 years is that electronic evidence has literally invaded every aspect of legal procedure. So we have it now in absolutely every single case, but then the problem that we've seen, and I know a lot of people today are going to talk about the post office issue in England and the miscarriages of justice that followed on from the basically the misworkings or the misinterpretation of data systems. It's an absolute fallacy to think that computers and electronic evidence and AI doesn't lie, because we know that it can certainly and has led to miscarriages of justice, which is very, very important as to how it's actually interpreted, and indeed what weight is given to experts who are doing the interpretation. So essentially, as we've seen from the Horizon systems issue that seen numerous miscarriages of justice go on, there was a tendency from the owners of the system and then from the justice system not to question the electronic evidence. It wasn't questioned for many years, and even when issues were raised, you know, by the humans who were affected, there was still a reluctance on the part of many legal brains who were involved, even to consider that, you know, that there might be an issue with the operating system or with the way that the data was reporting. It was just simply, no one even thought that it needed to be scrutinized. And, you know, that has to change. And whilst I'm all for embracing all types of electronic evidence, making it easier to admit them, as Daniel has hinted at, and even have an international standard, which would be absolutely fantastic, because we have evidence now coming in ways from all over the world that wouldn't have happened before. And we should embrace it and use it and make it easier to use. But it means that we need to scrutinize our experts all the more. So we have things like, there are different types of issues with reliability. So there can be the reliability of the data that a system produces, or that a system will interpret itself, given that we're moving into more structures of AI. There can be actually reliability of the electronic systems themselves. And then the most important thing is there's the interpretation of both of these. So in other words, we get onto the reliability of the human being themselves, who is putting themselves forward as an expert. So essentially, this is all open for what we look at in the future. It's really going to be an open playing field. But generally, with witnesses, what we will do, we need to look at the relevant qualifications. We need to look at what their history is, as we're used to doing. But we need to really challenge things that we have perhaps taken too much for granted in the past. about the way computer evidence works and how AI is going to work and come into play with how we interpret data, and then how we direct our fact finders via human beings, as it were. We actually haven't really learned that much in the last 20 years about scrutiny. And I think the problem is it actually involves quite a lot of money. So we shouldn't be actually just looking at expert qualifications. We actually need to interrogate down the systems and the processes that experts are using. And at the time that I wrote my book 20 years ago, there was a miscarriage of justice going on in England and Wales, a case of Sally Clark, who some of you will remember. And that had to do with the statistician's findings. Now, the thing was, what had happened in that case, there were statistics which looked as if they were compelling. But what the statistician had failed to accord weight to was that there were factors outside of the statistical evidence that put a completely different complexion on the overall evidence. And it had to do with statistics around the similar deaths of young infant babies that Sally Clark was the mother of. And what had been discounted completely was that there were details of infections as well that had totally not been brought into the statistical calculations, which, when viewed with hindsight, completely skewed what the statistics were actually saying. And from getting to a point where there were convictions, and the statistical evidence was of utmost importance in relation to the convictions, things moved completely through a 180-degree turn into where the statistical evidence, whilst it still had its place, it had to be viewed against other evidence, which actually then made the statistical evidence in terms of what weight it had in addressing the issues in the case, namely what were the likelihoods of 2 infant children dying of the same causes, completely turned the evidence around. So I think that the problem that we're facing in the future, the message really is that you need to scrutinize the experts' qualifications, but you also need to look at any case in the round, and not be overwhelmed by, which can happen, about whether digital evidence is infallible or not. We tend to think that digital evidence and evidence that's related to outputs and AI outputs tends to be completely beyond scrutiny, but it isn't on many levels. There are mistakes, and also we have to remember that AI technology kind of shows what it can see. So, for example, a camera might see a certain angle, but there might be something happening just off the camera, which puts a completely different complexion into the events that are being scrutinized. So what I'm advocating for is, by all means, we need to look at what electronic evidence is available in cases, but we need to make sure that we're bringing a human eye to that, and that we hold our experts up to the high standards, and not just assume that what they are looking at in terms of the systems, processes, and AI is an infallible thing that is not open to scrutiny. So, as we reach a stage where I think I'm probably not exaggerating to say, in one way or another, every single case, criminal or civil, within both the jurisdictions, is going to have some technological electronic input in the future. I don't think that there's going to be any single case anymore that doesn't have some kind of electronic flavor to it. Daniel mentioned the ways that social media now can come into cases. Now, social media has become very, very important within criminal and civil cases, because it gives a background flavour that simply wasn't there before. But again, as I sort of come to the end of what my my message is what I have kind of seen doing a review of cases where there have been miscarriages of justice and why there have been miscarriages of justice. It's often because there's been again, it's this undue, shall we say, undue trust in the technology, undue trust in the data, and also just simply being overwhelmed now with data, that it's not properly scrutinized. So for example, we can have criminal cases now that are generating, you know, millions and millions of pages, because we still look at pages. There may be a different way of calculating data in future. But when we have that, we simply haven't scrutinized it properly, or we can't do. So we now need to define ways in which we can use AI to actually be able to fully interrogate the amount of data that we have. And there can also be problems within the AI that we use. So for example, the AI may not pick up all the relevant things. So whilst technology improves and needs to be embraced, we need to invest money in the AI technology that we're going to use to scrutinize as well. And unfortunately, in criminal systems all over the world, we're seeing cutbacks in the money that's being invested. But we need proper systems, and we need to get to a stage where we have AI systems that help us do an initial scrutiny of a large number of documents. Then they're passed on to the expert. And in an ideal world, an expert would simply be a conduit that can interpret things in a simple way for the fact finder. And that would be the ideal place, but we still see an undue weight being given to expert evidence, and an assumption that systems and processes that experts use are correct. So we need to actually use more experts, I would say, which I know is very difficult in a publicly funded world. But we need to scrutinize the experts more. So it's not just, do they have the qualifications, but are they using the correct tools, which are often very complex and need scrutiny in themselves? Are they using the correct tools to scrutinize the electronic evidence or the data, when the data runs into, you know, millions of pages that is actually beyond human scrutiny? So we have to look at our expert evidence and our witnesses even more carefully in the future, because there are technologies that are happening now that we simply don't even appreciate how the interrogation of them can go wrong. So we have an exciting future planned where we can deal with this technology. We have systems that will allow us to scrutinize, you know, swathes of technology, swathes of data in ways that we couldn't have done before. But we need to look more carefully at what the evidence is saying. And we don't need to abandon, if I say this, abandon the human input into evidence interpretation. So witnesses will become, expert witnesses potentially will become more important, not less. And I think everyone needs to be, you know, educated in what can go wrong, to avoid things happening like the Sally Clark case, you know, where lives are ruined, and one life ruined by putting too much faith in digital evidence and statistics and data that's generated from statistics and from an academic database. One life is too much to be ruined, but we've seen actually with the operating system at the post office in England and Wales, that was many lives, through failing to really question whether the system was properly up and fully working in the first place. And I mean, that could have been avoided. And it was just simply, again, it was a change of mindset. So when it was pointed out in the relatively early days to the owners of the system, despite being told what could potentially be wrong with it, they were too quick to defend the workings of the system, which were then
sorry
later.
to
Yes.
interrupt, Lynne, could you wrap within a minute?
Yep, absolutely. So they were quick to defend that and to believe the system, as it were. So what my final message is, and thank you so much everyone for letting me be part of this, but it's essentially we need to scrutinize, and we need to have experts now in more cases and not less, and other people will be talking about the post office moving forward, and that's all the justification that we need to give high scrutiny to electronic evidence. So thank you very much for letting me speak, David.
My pleasure. Thank you, Lynne. Next up is Professor Burkhard Schafer, and he'll be speaking about AI verification and the implications for evidence. So when DNA evidence was introduced in criminal proceedings, it had triggered debate over whether quantification of match probabilities by expert witnesses unduly encroached into the territory of the jury. Over to you, Professor Schafer.
Thank you, and I will try to share my screen with my presentation.
And you have 20 minutes.
Yep. And that will be a bit of a challenge, not only because I misread a little bit the program and I thought I had actually more time, but also because when working on the project, I realized I really wanted to squeeze 3 papers into one. So we'll see where that gets us. This work is partly going back, what I report is work that we did in Edinburgh over the last 25 years, really, but some of it is in a very recent project, ISEC, AI Secure by Design, where we try to come up with methods to verify some properties of the latest flavor of AI, that is machine learning neural networks, which is particularly difficult sometimes to ascertain that they will perform according to certain specifications. So that's a bit of a background. But first I want to take you down a bit memory lane, because for me this whole debate started in the 1990s with Viper. Viper was a microchip, at that time extremely innovative microchip, which had as its unique selling point that it claimed to prove in a mathematically formal, rigorous way that it would perform correctly. That there was a mathematical proof that this chip did exactly as it said on the tin. It was as a result of that more or less written into some technical specification for military computing, for security sensitive computing that required suddenly that type of verification, and Viper was one of the few on the market who were able to do that. The way it did it was AI by the way it was understood at the time, so quite elaborate theorem prover assisting with that formal assurance. The problem was once academics accepted, put a higher degree of scrutiny to that claim, it turned out it might not have been all that it claimed. Donald Mackenzie, my highly esteemed colleague in Edinburgh, he probably wrote some of the ultimate analysis of this in both his paper in Nature at the time, but also in his book, which I strongly recommend to anyone who is interested in the notion of proof, the way technology works, but also how industrial lobbying sometimes shapes the way technology is perceived. The analysis that the academic scrutiny, especially by Cohn, realized was, yes, the Viper proof did prove something. The exact question was, what did it prove? What exactly did this formal proof reassure, and how complete was it? And he came up with this level model of propositions. On the top level is designer intentions, or the marketeers, the people who say this is what the chip is doing. Then there are lots and lots of different levels of formal abstraction that turn this designer description into a machine-readable computational format. mathematical format. And at the very bottom of it are the logic gate level description and then the physical device. And what he showed, what Kohn was able to show was, while the impression was generated that the formal proof directly and unambiguously linked the designer intention to what the physical device was doing, quite a lot of these steps in between were not proofs. They were something else, assumptions, models, theorizations, idealizations. When it became clear that as a result of that, the Viper chip was not quite as secure as people might have thought, the market obviously collapsed, and some of the companies involved with it sued. They sued the government, but also the academic who did the analysis for defamation and libel. So an interesting use here of the law to try to suppress critical material that allows us to do the type of scrutiny we just heard about from Lynne. Unfortunately, the leading company who litigated that went into bankruptcy before the case could reach final trial stage. And as a result, this really interesting question, what is the role of a mathematical proof as a type of evidence? What does it prove? How does it get introduced? What are the qualifications that are needed? Didn't get litigated, and as a result, there was no change in the law as well, no adjustment to this new form of evidence. Potentially a really interesting form of evidence, a mathematical proof that a physical device was doing a specific thing and nothing else. But how exactly should that play out? So there's a fascinating story with that, a mechanizing proof. Donald Mackenzie, I mentioned that book. I really strongly recommend it to everyone who is interested in that. And here's a choice quote from it. Mechanizing proof and in pursuing dependable computer systems, we should not obviate the need for trust in our collective human judgment. The mathematical truths cannot replace the judgment of a collection of people. And of lawyers as a collection of people, we should, of course, immediately think of the jury or maybe a panel of judges as the type of collective judgment making. Quick fast forward, and that gets us very close to what Lynne was talking about, the early 2000s, where you get a lot of articles that express or use the identical term trial by number, a concern that starts increasingly getting voiced that the administration of justice, the criminal trial, became number obsessed, that numbers were introduced sometimes and mathematical proofs were introduced in sometimes haphazard and misleading way. This is one where a mathematical proof was given, or an attempt was given, to quantify the reliability of speedometers used by the police to track speeding offenses, and it turned out that the way this proof was introduced, the reliability was quantified, had a rather similar problem to the Viper one. It had analyzed abstractly what the software in that system was doing, but it had failed to take into account all the problems that come with the physical manifestation of the actual machine, which is then held in the shaky hands of an actual human being. So we get a proof that proves something, that mathematically demonstrates something, but not really quite what we maybe expect it should have shown. That's another one talking about DNA evidence. DNA evidence, I think, was a sort of groundbreaking technology that introduced a sort of quantified approach to evidence in the courts. Yeah, here, get it. The big debate, and again, Lynne mentioned a little bit of this, is should this type of evidence, this quantification of probative value of statements, be admitted in proceedings at all? And if it is admitted, how should it be communicated? How can the expert really explain to the collective human intelligence the scope and limitation of the mathematical formula and the evaluation? And also, what is quantified here? Again, that goes back to Viper. Do we talk abstractly of the theory or the concrete lab and processes or persons? So if in a DNA case we get a report of a match probability of 1 in a billion, what does this quantify? Does this quantify a theory of biology that tells us about the distribution of traits in DNA abstractly? if everything went perfect? Or does it quantify how that specific lab with that person whom they hired using that specific type of 5-year-old equipment is likely to get the correct result? So we get two very different ways in which we can think of giving mathematical numbers to the validity of a piece of evidence. Quite a lot of skepticism also by the judiciary. Just one choice quote I want to read out because of time. To introduce Bayes' theorem or any similar method into criminal trial plunges a jury into inappropriate and unnecessary realms of theory and complexity, deflecting from their proper task. So the historical division that the expert gives the facts and the jury evaluates how persuasive these facts are, they got challenged by the mathematical approach to evidence. Suddenly, the expert talked not just about the facts, but also what weight should rationally be given to these facts if you are, for instance, a Bayesian. And the question was, should the legal system permit this even? I think, by and large, we've agreed that very often that is appropriate. Very often now DNA evidence is routinely quantified. We have developed some rules in the US following Dobart, for instance, what is necessary, what should be reported, how they should be reported. Just want to bring up one very quick example that is problematic, and we will come back to that later on. People against Pizarro, a very controversial DNA case. And the question here is, when reporting the match probability, what is the reference population that you refer to? Are they all humans? Are they all humans of the ethnicities likely to live in the vicinity where the crime happened? So for instance, in the US, in the Pizarro case, that was Hispanic, Black, and white, Caucasian, but not, for instance, the genetic profile of a Maori population. So a huge discussion about bias, the impact of selecting the right database, the impact of racial profiling, potentially, the question whether these issues are epistemological or logical or ethical in nature, and disagreement amongst forensic scientists and courts. They all answered that question differently, but an intensive debate, what is the right way, run by expert, to quantify this type of expertise. And I will come hopefully back to that. At this point, Stephen will say, Burkhard, have you mixed up your conferences again? Start talking about computers. And I think I do, because I think of these three, all of these are statistical forms of evidence: DNA, fMRI, brain scanning evidence, and exactly the case we just heard from Lynne, the Sally Clark case. Of these three, all of them shaped the use of statistics in criminal trials. One of them is the odd one out, one of them is different. And I think it is the Sally Clark case, because on an ontological level, we can of course think of the cell as a computer and DNA as a code. And we can even think of it as electronic evidence because there's a small electronic charge when that processing takes place. With the brain, it is even more the case that we can, and often do, think of it as a supercomputer. So what we don't do in law is to treat organic computing like silicon computing. We have very different rules for DNA and for fMRI than we have from evidence generated on computers. But at least on a philosophical level, and if we take the idea of technology neutral rules of evidence seriously, the one Daniel mentioned, we could wonder if that is the right approach and whether we should not treat these things as computational devices. In our book, in the second chapter, where I'm a co-author, we actually discuss a little bit of that. This will become even more pressing if we have brain and computer interfaces, where it really becomes questionable whether a certain processing took place in the organic part or in the silicon part of a human if they are implants. Which set of rules applies here? I think they are also similar in a different way, both with DNA evidence and with fMRI evidence. We sometimes forget how much computer mediated they are, how much AI already goes into interpreting these results. what type of genotyping standard, what type of software you are using when you are doing DNA analysis matters massively for the outcome, as does the software that is used for fMRI. This is probably, by the way, machine learning AI because it learns to interpret these pixels in a correct way. And we know that this can have massive impact. The infamous case of the dead salmon, they put a dead salmon in an fMRI scanner and were able to prove with a high level of probability that it was able to recognize human faces, even though it was actually dead. The way they achieved that very intentionally was to manipulate the statistics software, the AI of the system, to interpret these pixels in a specific way. Still, we do not think for procedural purposes of DNA evidence and fMRI evidence as computer evidence. We use different approaches, different types of rules. I think this is potentially quite problematic. So if you have this really big vision of a unified theory, you might go a little bit beyond that. One interesting thing that came out of this debate was one of my favorite ways to organize evidence developed by the UK Forensic Science Service at the time, the hierarchy of propositions that shows how many assumptions go from what the scientist really does on the lowest level, very similar again to the Viper graphic, to the highest level, the legal probandum, that what the law actually has to show. And all the interpretative steps, the things that are not mathematical, that flow into this. So a similar issue here, I think, identified and dealt well with for DNA evidence, not done well yet for computer evidence. And there's, I think, a chance of learning that we should exploit more. We at the time used AI in a third level. Again, a bit like Lynne indicated, we took the model of the Forensic Science Service, the hierarchy of proposition, and turned it into a Bayesian network to assist the lawyers to evaluate these probabilities in an automatic way to avoid mathematical mistakes. I'm not going in any great depth into this. Just one side comment here. We have here at least two types of use of AIs. We have the AI that is incorporated in, say, DNA analysis in fMRI scans. We have AIs that is used, like we did, to help the lawyers to interpret it. Under the current proposal for an AI Act at the European Union, these systems potentially would be leveled to greater scrutiny. As AIs that are used in the justice system, they are high-risk systems, Article 2, and that would come with a massive amount of obligations on the developers in terms of transparency, explainability, unbiased data sets, debiasing, because we do not think yet of DNA evidence and fMRI evidence and all of these other evidences as AI evidence or computer evidence. People haven't realized that. But if you read the text, I think they apply, they are in scope. And that gets me to a worry, I would say. If you think again back to People Against Pizarro, there was a debate amongst evidence lawyers and courts. How should we in a just way use statistics to quantify match probabilities? If my reading of the AI Act is correct, this now becomes a task, at least partly, of the consumer protection agencies and the market surveillance authorities, because this product is a product and because of that is regulated. So we get a conflict of responsibility. Should the rules of evidence be done by evidence lawyers and by criminal courts, or by commercial lawyers and commercial courts? So potentially quite interesting development. Now let's go back to what we are doing, and hopefully I have another 3 minutes or so to finish this off. The issue is increasingly... Sorry?
You have 5 minutes.
5 minutes. Oh, excellent. That should be more than enough. We increasingly, again, as we have heard, get evidence that is generated within AI machines, which these days means machine learning. So we have evidence created in autonomous vehicles. We have evidence created by automated facial recognition. And for us in the ISAC project as well, and in the Trusted Autonomous Systems project, the question now is how this new type of evidence, the one that is generated without direct human input routinely in our day-to-day interactions with machines, would feature in the type of Bayesian network analysis, a type of third level AI that can be used to make a more rational assessment of their probative value. And that is a little bit what we also try to do with ISAC. We try to think about what type of property can be proven in a quantifiable way or in a rigorous deductive way of some of these machine learning systems. So that is our team, mixture of computer scientists and me as lawyer, Harriet Watt and Edinburgh in collaboration. Some of the results that we already have, and the result is, yes, we can verify certain properties even of the most complex neural network machine learning algorithms. It's very difficult, but it is possible. Yet the problem is exactly like the one we had in the 1990s with Viper. It is not clear what exactly that proof tells us. So here's one of our case studies, for instance. We want to show for an autonomous car and its speed and steering control that regardless of how strong the wind from the side is, it will ever stay on the middle of the road. And there are certain things we can formally now verify about the neural network that senses how much wind there is and then adjusts the steering. So we can categorically say that certain things can't possibly happen. But what does that mean? Does that mean the car will always stay on the road? No, absolutely not, unfortunately, because there are so many idealizing assumptions here. For instance, that the road is perfectly flat. That would not apply in real life. We assume that there is no dirt on the sensors because that is something that is outside the mathematics of the network. So again, we have lots and lots of intellectual gaps between the physical manifestation and what the neural network is doing. The second one we have is bot disclosure laws. Under some laws, bots now have to disclose that they are bots if you ask them. And we wanted to verify that the bot will always recognize a request to identify itself, regardless of how the human asks the question, are you a bot? You're a bot, aren't you? You bloody machinery, you are a bot, you... Regardless of how many swear words are in there, the AI will recognize I was just asked to disclose myself, and therefore in a law-compliant way I have to tell who I am. Again, we can do some of it. We were able to show some verification is possible. We can prove that certain mistakes won't happen, but the gaps between that and what the law requires are still quite significant. So again, we came to a hierarchy. The properties that can be verified tend to be on the very, very low level, industry standards and guidance notes. But to reach from there to what the law terminology is, what the predicates are in the law, requires significant abstraction and additional steps of inference. So for me, the interesting thing will be how can we turn these DNA ideas about the category or the hierarchy of propositions in an AI world. Here's one of the attempts how we did this, where we wanted to show that certain formal proofs give us high confidence that the resulting system will comply with the law. But to quote with a quote from Voltaire, doubt is not a pleasant condition, but certainty is absurd. I think as important as to try and push the bounds of verification, we have to learn the lessons from the 1990s. We have to see how far exactly these formal proofs match of what the law requires. And that is unfortunately considerably more complicated than what the mathematics seems to indicate. Thank you for your time and attention.
Thank you, Burkhard. On to our next speaker, Professor Luciana Duranti, and she'll be discussing the authentication of electronic evidence. The presentation will introduce the concepts of identity and integrity, accuracy and reliability, and will show how authentication in the digital world will be increasingly based on circumstantial evidence rather than on electronic material submitted as evidence itself. Over to you, Professor Duranti. You're currently muted.
Okay. All right. Hello, everyone. So I will be talking about authentication. And I will start, as I always do, by defining the way in which I use the terms. Authentication is a declaration of authenticity, which is based either on direct knowledge, on material proof, on inference, or on deduction. So authenticity means to be what something is purported to be. Note that authenticity is only one of the three components of trustworthiness. The other two are reliability, which means that evidence is actually saying the truth, and accuracy, that the data are correct and precise. There are different processes for assessing reliability and accuracy than there are for assessing authenticity. So my discussion of authentication will focus on authenticity. To explain with an example, you can have a birth certificate issued by the right authority in the right form, according to the right process, that has an incorrect date of birth and that lies about who the father of the baby is. It's still an authentic record, but is not reliable and is not accurate. So when I focus on authenticity, I am actually focusing on the fact that evidence which is submitted as proof of something is what it purports to be, not that it tells the truth. So in the 17th century, a science was developed called diplomatics, from diploma, which in Latin means record. And this science was concerned about the authenticity of records that, of course, gave property and rights to people. Since then, it has developed with the development of technologies over time, and it has grown, and it has established a scientific methodology for determining authenticity. It has examined specifically the form of the documentary evidence, that is, the rules of representations that are used to convey a message. Now, increasingly, this analysis of form that diplomatics has carried out over the centuries is used for labeling documents in machine learning. And it is very useful for that. We're doing it now in the latest project about the use of AI for authentication. Also, it based its declaration of authenticity on the degree of perfection of the record. So whether it was a draft, that is something generated only for correction, whether it was an original, the complete, perfect document capable of reaching its purposes, or whether it was a copy generated for purposes of communication. So what is important about diplomatics that has been used over the centuries everywhere is that its approach is to establish on the documentary evidence itself that it is what it purports to be, or what whoever submits it claims it to be. In archival science, authenticity is one of the qualities of every document that is made or received as a byproduct of activity and kept. That is, of every record. In common law, we call them the business record. All records are authentic with respect to the person who makes or receives them and who keeps them for further action or reference, even if, when, from a diplomatic point of view, they may be forgeries, as long as the person who makes or receives it and uses it for action or reference, in fact, believes it to be an authentic record and treats it as such, that record with respect to that person is authentic. So records are authentic when they are made or received and kept for the need to act through them, and when they are preserved as witnesses of facts and acts by the person who makes or receives it or its legitimate successor. for example, archives. So what did archival science? Archival science extended the concept of authenticity from being a property of the record itself to being a property of procedures, and tied it to unbroken custody. So therefore, it linked the record to its context of creation, of use, and of preservation. And this is very important for digital records. So authenticity in the digital environment, what is it? Well, in archival science, there was no question that authenticity resided in the provenance of the record and the documentary context of recorded evidence. But it turns out that this fact was linked to the immutability of documentary evidence that is affixed to a medium permanently, that is, to its integrity. Now, the Interpares Research Project, which since 1998, through 5 phases that still last today, has tried to find ways of demonstrating the authenticity of records through the evolution of technology, understood already at the very beginning that in the digital environment, authenticity can no longer reside only in the context of documentary evidence. Because even if such context remains intact, the documentary component of the evidence can lose integrity. Why? Because in a digital environment, content, structure, and form are not linked to each other. So the Interpares researchers decided to look separately at identity and integrity. So as identity, they took it to mean the attributes of an entity that uniquely characterize it and distinguish it from any other. They include the names of the persons that participate in the making of this document or any piece of evidence, author, addressee, writer, originator, creator, you name it, the dates of making, receipt, filing, transmission, the method or action in which the document or the evidence participates, the expression of relationship with other entities, and indication of attachment. Integrity, instead, refers to the quality of being complete and unaltered in all essential respect. Well, we have never been fussy about this. We have seen parchments that had holes in them that were burned on the side. We have seen the paper documents with the ink passing through on the other side. As long as we could understand the record, then its integrity was a given. It was good enough. But what is good enough in the digital environment? I already mentioned it, that content, structure, and form are now linked. What does it mean? It means that the piece of evidence you have has two parts as a spore entity, its encoding, which is distinct from the manifested entity, what you see on the computer screen. And the digital components of the stored entity have to be considered together with the manifested entity form. So you have to look at two things when you look at authenticity, not just what you see on a screen. You have to figure that the digital components in the system are actually intact. So what do? Let's say you receive a record, an email. When you save it and you close it, you actually take it apart. The header goes in a place, the message in another, the block signature in another, and so on. So those are the digital components that are in the system. When you retrieve it, you recall it, you actually create a copy. You create a new entity. Digital records are always new. Although we should be able to generate the same manifested entity from the same digital components, there are no originals in the digital environment. And furthermore, it is not possible to preserve electronic evidence. Remember this, it is not possible to preserve electronic evidence. We can only preserve the ability to reproduce it when it has an analog counterpart, or recreate it when it has no analog counterpart. Think of a database. In order to see the same manifestation that you had seen before closing on the screen, you need to ask the same query, hoping that you get the same response. So, in fact, you're recreating the record. So keeping electronic evidence involves the process of making authentic copies of digital material or recreating it and keeping it accessible during and across different generations of technologies over time. So what are the bases for the authentication of electronic evidence? Well, a chain of legitimate custody remains a significant ground for inferring authenticity. And you say, what are you saying? I can't trust the record, so I trust the custodian. Well, that is the traditional way that ancient Roman authenticated records. So they would write on wood covered on wax. Nothing is more fragile than wax. So what they did, they locked the records under the control of the censors, and then they had clerks who made copies under the control of the censors for access. So can't trust the record, trust the custodian. You have a digital chain of information that is the identity and integrity metadata, which are linked to the electronic entity, must be preserved and maintained. You also need a declaration made by an expert to base it on the trustworthiness of the system hosting the material and on the procedures and processes controlling its preservation and use, which we call system integrity and security. Note that I put an S on the trustworthiness of the systems, because if the same evidence has been through time in different systems, you have got to verify the integrity of each and every one of them through time. So system integrity and security come into play in jurisdictions such as Canada, where authentication is based on an inference made from the technological environment in which the records exist at any given time. Now, because of the vulnerability of digital material and the impossibility of establishing authenticity by examining the digital evidence itself, the identity and integrity of this entity can be deduced from the system's requirements on access. Who can access it? Who can use the material in it? Who manages it? Etc. And this is the reference to our Canadian standard for doing so. Now, this implies that we need very strict policies and procedures for controlling all the records in a system, as well for controlling any interaction with those records within the system and from outside the system. However, this only happens in institutions and organizations that have their own information and preservation systems subject to mandated standards of practice. What if you put the things in the cloud? When organizations and individuals entrust their records to cloud providers, it is not possible to verify the integrity of the data centers where the material is. It is only possible to examine the security measures agreed upon in the contract between provider and user and make an inference of authenticity from them. We can still determine authenticity on the basis of the electronic evidence significant properties. You remember the metadata necessary to establish identity and integrity. These metadata are produced when a digital entity is generated. Those are the identity metadata. And during the use and management of the entity, those are the integrity metadata. But also after, they are set aside for permanent preservation and given to a cloud provider. And this is a problem because these metadata, as well as significant properties like logs, are not accessible if the records are entrusted to a cloud provider. The cloud provider owns all the properties that it adds. So in conclusion, the fundamental difference between the authentication of analog and electronic evidence is in the fact that while analog material can be authenticated on its face, for example, you can do the carbon 14 on the paper. You can examine the quality of the ink. You can look at calligraphy. You can look at stamps, at the structure of the discourse. Only exceptionally, you need circumstantial or extrinsic evidence. But the authentication of electronic material is always an inference, which is based on extrinsic elements such as significant properties, the metadata and the logs, and relies on circumstantial evidence such as the integrity of every single system that at any given time has hosted the record or the evidence in general, even if it is not the record, the policies and the procedures controlling the system, and the technology encrypting or securing the access to the system. In fact, if you think about it, security is the new authenticity, because authenticity not being verifiable, it's always an inference. And what better inference making it from the very tight cybersecurity to which a system can be subject. But there is also technological authentication. Can it be the answer? Can blockchain be the answer? Maybe. Allison Stanfield will address this question. Thank you.
Thank you, Professor Duranti. I'm not sure if Allison's going to answer that question. I'll leave it up to her. Next up is Dr. Allison Stanfield, and she'll be speaking about authentication issues in relation to distributed ledger technologies and crypto assets. What do the NFTs have in store for us, evidence? Over to you, Allison.
Thanks very much, David. I'll just share my screen. Can you see my screen, David?
Not yet.
Not yet, okay.
I don't think it's shared. I can see you, but not the shared screen. Yep.
Now?
It's
Right.
good. You just need to go to slideshow mode.
Yep.
And that'll be good. Yep, perfect.
Okay. I'll just preface this by, I have a terrible cold at the moment, so I sound very stuffed up, and I'll try not to cough, but please excuse me in advance if I do. Okay, so I'm going to talk about the authentication of crypto assets. I find this a fascinating area. It's obviously everyone's heard of crypto assets. Everyone's heard of the rogues that are out there stealing Bitcoin or Ethereum or what have you. And we're starting to now see some cases come before the court. So there's a bit of law happening in this area as well. And it certainly is a fascinating area. So thanks, Luciana, for setting the scene in terms of authentication and actually specifying how difficult it can be to authenticate digital evidence. Now, just by way of overview, I'm going to just talk about some of the terms that are used in distributed ledger technology, which leads on to blockchain, cryptocurrencies, crypto assets, smart contracts, and non-fungible tokens. I know there's a number of people in the audience, and I'm just not sure, some of you may not have heard of this stuff. There may be some of you who actually are quite experienced and have actually run cases. So hopefully I will strike somewhere in the middle. So for those of you who are all over these terms, please forgive me and bear with me, but obviously there may be some in the audience who, you know, may have heard of this but don't really understand what it is. And then I'll move on to actually looking at this from a legal perspective in terms of, you know, some of the challenges that can occur. And then I'm finally looking at non-fungible tokens as intellectual property, and there's a whole area arising in this respect out there at the moment as well. So first we'll just look at some terms. So firstly, distributed ledger technology. Simply a digital system for recording transactions, and it's distributed across multiple locations, hence the term distributed. It means that there's actually no central data store. The records are only stored in the ledger once the parties reach consensus. And that leads on to blockchain, which is a type of DLT, but the transactions are stored in blocks. So a blockchain will always have what's called a genesis block, which will be the first block. And that is then added to. Each block has a hash, which is an algorithm generated as a checksum for the data in that block. And that serves as authentication of what's in that block and so on. And so as the block grows, the hash in the previous block is checked as well, so that the purpose of that is it gives some immutability to the blockchain. Now there's question marks over that, but obviously if we can have something that is immutable, that does go some way towards you know, helping us show that transactions are actually authentic. The blocks are append only, so you can only add to blocks. You can't go back and add blocks in between other blocks, and you certainly can't change blocks. Again, it's decentralized in the same way as the DLTs. Non-fungible tokens, they comprise digital data stored in a blockchain, and they're uniquely identifiable. In other words, they can't be replaced. An NFT is designed to be unique. It's an asset that can't be replaced, just like a Monet painting, for example. The NFTs are designed to give some level of proof of ownership in assets, whether that's a digital asset or a physical asset. And I'll talk about this a bit further down because the NFT on the blockchain really just points to ownership. It doesn't actually contain the asset. That could be elsewhere on a network, or it could actually be a physical asset. Excuse my voice. Smart contracts are also used, and essentially what they are programs, often simple programs, and they have if, when, then statements stored on a blockchain. And they will run if predetermined conditions are met. So for example, pay this money, well, once those funds are paid, then issue a ticket. Okay, so they are wrapped up in the blockchain. Again, they're authenticated, and things can then happen, or predetermined things within that authenticated environment. Crypto assets, simply an asset that lives digitally. Okay, and I guess this is what a lot of people are struggling with. I've had a lot of conversations with people, certainly in recent times, about cryptocurrency, and there is obviously a lot of distrust around the fact that it only lives digitally. You know, for all the reasons I think Luciana just mentioned, you know, that you can't touch it, you can't feel it. There's a whole host of things that have to come together in order for you to have that asset. Obviously, one of the biggest examples of a crypto asset is Bitcoin, and there's now numerous other cryptocurrencies such as Ethereum and a whole host of others. And of course, you've got NFTs, which I mentioned. So Bitcoin was the first cryptocurrency. It was actually invented, in inverted commas, by someone using a pseudonym of Satoshi Nakamoto. And that person or persons, they don't know who it is, published a white paper back in 2008, which described how this cryptocurrency could exist and be developed. Now, 2008 is no coincidence. What happened in 2008? That was when the GFC hit. So we had trust in big banks suddenly disappear. A lot of people lost a lot of money. You know, the perception was that there were the big fat cats on Wall Street. They'd taken the money. There was very few prosecutions that happened out of that. And so, you know, a lot of disaffected people thought that, well, it's just a big club. You know, they're in there looking after themselves. What can we do that's different? Okay. And essentially the cryptocurrency came about so that, you know, you could actually have a currency that wasn't managed by a central repository. So it's interesting. I think the current price is about 20,000 US dollars. I think I looked at that this morning, and I think the highest was around 64. So it's still very volatile and it's still finding its feet. There's a lot of talk about regulation and, you know, being able to, you know, particularly with crypto exchanges, getting that back out into fiat currency. The courts have actually recognised cryptocurrencies as assets, and that happened last year in a case called AAA and Persons Unknown in England and Wales. So interesting how there are now a number of cases where the defendant is actually a person unknown. I'll talk a bit more about that in a moment. So I won't dwell on how Bitcoin works. I'll just quickly go through the process, just so that there's a bit of understanding, so that when we talk about, if you're looking to try and authenticate some of this evidence, there's just a bit of understanding of how it all comes together. So essentially, a Bitcoin transaction is requested and authenticated. A block for that transaction is then created. A block is then sent to all the nodes, and a node is just another word for computers on the network, okay? So they then validate the transaction, and again, the whole purpose of blockchain is it's not centralized. You have to have a number of nodes out there who act by consensus, and consensus means 51% or more. Now, I won't dwell on proof of work because this is actually a very interesting way, but essentially for more Bitcoin to be created or mined, there's a complex mathematical equation that has to be achieved for new Bitcoins to be created. And these miners, as they're called, will get Bitcoins as a reward for proving the proof of work. I don't understand that mathematical equation. I work with a PhD in maths for a particular client, and I've discussed that with him, and even he says, look, I don't really understand how it works. All I know that it takes a long time and takes a lot of computing power, and that's why there are rewards for getting achieving the proof of work and ultimately being able to add the new block to that existing blockchain. And it's added to, and then that whole block is then unchanged and authenticated. The updated blockchain is then distributed across the network, so everyone has a copy of that, and then the transaction is complete. So crypto assets is evidence. Interesting. So it's like any asset, okay? It can be stolen, it can be exchanged, it can be misappropriated, and also there's rights that attach to that asset. So how do we deal with those? So, there's all these legal questions that come about, but really they're no different to the legal questions we've always dealt with, okay? But collecting and authenticating the evidence can create issues that we perhaps might need to think a bit more about. So for evidence to be, put into a hearing, it first needs to be admissible, okay? And to be admissible, it must be relevant. It must be relevant to the facts in the case. Okay, and admissibility is a legal question for the judge. Once it's admitted, the party can challenge its authenticity. And depending on which jurisdiction you're in, there may be early challenges. It may come when the evidence is actually admitted. Depends on the rules of court and your rules of evidence. But generally, that's the way it will work. It's then up to the trier of fact. So if there's a jury, they will determine authenticity. If there's no jury, then it will be the judge who sits in that role to determine authenticity. So, if authenticity is in question and one party is put to proof as to authenticity, then you have to think about how you're going to do that. Okay, and I'll talk in a moment about an interesting case where, that is being looked at. So Luciana talked about what authentication is. Essentially it has to have integrity, it has to have reliability, it needs to be uncorrupted, and probably first and foremost, it needs to be trustworthy, okay? So what sort of issues do you have with authenticating, these transactions on the blockchain? It's immutable, it's all there, the algorithms are there, there shouldn't be any problem, okay? Well, firstly, how do you, what's your evidence? There's no single controlling entity. There has to be a consensus across networks. So if you are put to proof, how do you go about this? Also, how are you going to do it? This is complex stuff for people who aren't technical. So you are probably going to have expert forensic help, or you will require expert forensic help. And Lynne talked about this early on and how we're probably going to be relying on experts more. And again, being very careful about that. So, you know, using tools and are they themselves authentic? And I'll talk a bit more about that in a moment. You'll have jurisdictional issues, obviously, because you may have nodes in other countries, you may have transactions in other countries. How does that all work? And then I think the big one, though, is if you are looking to sue someone, how do you find evidence of the person who has transacted on the blockchain? And that's probably one of the biggest challenges that we have in blockchain transactions. So I mentioned that during the proof of work, you've got to have a consensus of 51% or more. So it could be the case that you get a rogue number of parties together that comprise the 51% and attack that transaction and take it off. And that's actually happened, okay? Blockchain can't be corrected, and the only way to do that is to create a fork, which again has to be done by 51% or more. And that's already happened, particularly in the Ethereum cryptocurrency. We now have Ethereum and we have Ethereum Classic, which is the old one. Also, blockchain and its use is software dependent and therefore subject to reliability issues. And I know Stephen and Daniel are going to talk about that a bit later and focus on the post office case in the UK. So I think we've just got to be very careful that all of this, again, is within the realm of software and, you know, digital things that, you know, not everyone understands. Also, smart contracts can be flawed and difficult to fix, as was seen in a case in the Singapore High Court in 2019, where a mistake was made by an automated process. Obviously, the one party benefited from that mistake because they got more than they should have under the smart contract. But the court actually just applied standard contract law regarding mistake and said, well, it wasn't a mistake. You guys agreed to that. Just because the software was flawed, it is what it is. So, you know, these sorts of issues are arising and need to be thought through. With the how, expert evidence, as I said, may be required, and also forensic tools. So if you're looking at analysing transactions on the blockchain, and the big benefit of blockchain is that all the transactions are recorded. So it's all there, it's all authenticated, you can see everything. So analysing those transactions, and there's a myriad of tools on the market, both commercially and also non-commercially, that's used by law enforcement and so on. And they provide the analysis in a graphical format, which makes it much easier to understand. There's also the jurisdictional issues I talked about. And I've sort of been thinking, and there's now some actions being taken by private individuals, for example. So, you know, if they've been, defrauded or had investments that have gone awry because, you know, people have done the wrong thing, how can private individuals take action? And obviously working with law enforcement is a big one. But they can actually now get civil orders, including freezing orders, injunctions. If you don't know who the person is, get what they call an I am Spartacus order. And again, you know, the courts are happy to make these orders, notwithstanding they don't know who the person is.
Allison, sorry, I just want to remind you, you have 5 minutes.
5 minutes, thank you. So the who, so blockchain transactions were previously thought to be anonymous. And this was until about 10 years ago when Mikkel John, who was a PhD student, and her colleagues actually found that, yeah, all the transactions are there. If we sort of look at the IP addresses that are captured and see who's doing what, we can actually analyse. And as soon as we can, you know, work out where someone is and if they've got certain handles that they use, it actually becomes possible to identify the person. And they call it clustering heuristics, which is simply just, you know, if A and B transact and B and C transact, then, oh, excuse me, then generally you can see, you know, who's doing what. So that's generally, you know, what's being used now. An interesting case in the US, it hasn't gone to trial yet. They're actually, I think, negotiating a plea deal. Liechtenstein and Morgan, another husband and wife case. I think Liechtenstein is on remand, but I think his wife's out on bail. Interesting case. They're charged with conspiring to launder about 120,000 Bitcoins, which over time became billions of dollars. They tried to launder it a number of different ways. The problem with Bitcoin is there's not much you can do with it unless you buy stuff on the dark web, or really the only way to get it is to get it out to fiat currency. And of course they couldn't do that because the minute they did that, they would have to identify themselves. I'm running out of time, but I wanted to just say that there's a really interesting statement of facts by one of the IRS investigators, and shows you how they track the transactions and ultimately how they got caught. And he also does a summary, essentially a couple of things. One was that Liechtenstein had stored his private keys in a cloud storage account, which was accessible. So law enforcement got hold of that. And ultimately they did a couple of transactions where they could be identified. And I think the other thing is they did that in the USA. So law enforcement could get hold of that evidence. I mentioned unknown persons. I've just listed some cases there where courts will make orders to unknown people, including freezing orders and even disclosure orders. And more recently in the Supreme Court of the State of New York, we've got a matter where a John Doe, so an unknown person, was actually ordered to be served via NFT, so non-fungible token. So just to wrap up, NFTs as intellectual property, as I mentioned, doesn't necessarily give you proof of ownership of the asset itself unless you've got a legal document assigning the intellectual property to that asset to you. There's another recent case involving NFTs where someone created NFTs of an Hermes handbag. Hermes didn't take too kindly to that, and they have sued for trademark infringement and cyber squatting. Rothschild, the fellow who developed the NFTs, brought a motion to dismiss it, saying there was no claim. The judge denied that, excuse me, and made it clear that there's certainly a case to answer. So it'd be interesting to keep an eye on what comes of that case in terms of breach of intellectual property. Oh, excuse me. I think I'll stop there because I'm losing my voice, other than to say lots of interesting stuff happening, and watch this space. Thank you very much.
Thank you, Allison. And now we've got a short Q&A session, which I believe would be about 10 minutes, and that'll be moderated by Daniel Seng. So over to you, Daniel.
Thank you, David. Perhaps let's start with some questions that are in the questions and answer tab. So Kevin Chua asked the question intended for any of the panelists. In the context of blockchain transactions and other infrastructure that use private keys, how would a counterparty be able to verify the identity of the person signing? After all, the use of private keys implies that at least one party wants to remain anonymous or pseudonymous.
Yeah, that's a very good question. And that's exactly right, that transactions on the blockchain are intended so that people can remain anonymous. And that is the case. And unless and until, you know, something happens for which a claim needs to be made and that identity needs to be uncovered, it can be difficult to track, but it's not impossible.
I suppose, Allison, the other point we made is that in many instances, we do not need to know the identity of the
That's
party.
right.
Yes. especially if the action is directed at the intermediary. Maybe I'd like to elaborate on this in a little bit more detail.
Yes.
Apologies.
Sorry.
I think, Allison, you were about to explain the part about the action that is taken against intermediaries, which would not require us to establish the identities of the individual participants who use the private keys.
Sorry, yeah, so they will remain anonymous, and it's only if you know, something happens and a claim needs to be made and that person needs to be pursued, you know, how you go about that. And you know, because every transaction is logged on the blockchain, but you know, essentially if that person doesn't want to be found and they've covered their tracks very well, you won't find them. Yeah, so you know, and that's, I guess, opening up now that governments are very cognizant of that, and it's great for people to remain anonymous, but it also means that that element of trustworthiness when you're dealing with cryptocurrencies goes out the window. You know, is that, I guess it's, if you look at it on the other side of the coin, it's, you know, we carry cash around, and if someone comes up and steals the cash and has a ski mask on and gets away, you know, you'll never find them. So it's a similar scenario. I guess it's just a question of how far we want as a society that to be regulated, because I think it's coming. I think cryptocurrency will be regulated at some point.
If I can budge in there, there's a sort of interesting parallel there to the type of online ID verification that became popular during COVID, where you have to prove to a video camera that you are who you are, for instance, for banking purposes. So I was asked to hold up my passport, to hold it then from the right a little bit, to move my hand for it, so that the person on the other side could see that it was really me doing all these things. And that has become a security standard for quite a lot of online banking. There are now recent cases where deepfakes have been used to overcome even that type of human identification in an online transaction, with some question marks if that is even illegal, as long as no actual fraud has happened. Simply fooling that authentication system might just stay on the legal side. But here we have something that is more human involved, if you like, than the blockchain is. It's an attempt to restore a way to identify yourself online, but as soon as you have the digital intermediation, it can be changed, it can be circumvented. No amount of sophistication that was used, and I had to almost do impressive dancing to convince a person on the other side that it was really me, and holding up that passport. None of them have so far proved to be absolutely foolproof.
Yeah, I think Luciana, you want to say something?
Yeah, there was a question that I said I would answer orally, not in writing, which was about preservation and blockchain. And the person said, but blockchain wasn't it generated to preserve the records? No, it wasn't. It was created to authenticate the records, and there is no records on blockchains. On blockchain, there is the hash of the digital evidence. The digital evidence is kept somewhere else. Now, the problem with having the hash, an algorithm on the blockchain, is that involves bitwise integrity, which means that the original material that has been hashed on the blockchain must maintain over time the same bits in the same order in order to have the same value. Well, that is not possible. Every time you upgrade a system, or you move the material to the next system, or you transmit to somebody, at least one bit changes, which is the ones related to time. Not only, but the blockchain does not keep a hash of the metadata, which are the key component for authenticating records. And so therefore no relationship of a record to other records. And it is useful, but it is useful for contemporary purposes. That is, if I have a record that I want to transmit to an entity, and I want to be sure that this entity is able to verify the authenticity, I can put it on the blockchain, can be approved by the entire consortium, etc. And then the person who receives the entity goes and verifies, doing a hash of the entity that he receives, that the hash is the same as the one on the blockchain. But over time, even over a month, the material, the original material changes. Not only, but who tells you that it was authentic in the first place? When I made an hash and I put it on the blockchain, that's another big issue that exists there. So there are big issues with the blockchain. It is useful for very specific purposes and mostly with current material. Contracts are not considered record yet by no jurisdiction that I know, the contract on the blockchain, because they have no date and no signature. Yeah, you cannot preserve digital records, blockchain or not blockchain. You can only preserve your capacity to make a close as possible reproduction of the previous one across system, migrating it across system. And that's where the analysis of the system comes into place, and the reliability of the custodian comes into place, of those who actually do the work. Done.
Thanks, Luciana. Thanks, Luciana.
Speaking of custodians, I think Kelvin had a follow-up question in relation to the distinction between a hosted or hot wallet, which is maintained by intermediary, and a private unhosted wallet, which is obviously maintained offline. So he's wondering if a court will be prepared to make an order against the owner of an unknown John Doe wallet. I wonder if any of the panelists have any thoughts about this.
Well, they've already done that. Well, they haven't actually made an order, but what they've done in that case that I mentioned in the New York courts was that the court made an order that service of proceedings be made via NFT. So it was on the Ethereum blockchain. The transactions that they were after, they had tracked them, but they didn't know who the controller was, but they had an association with the NFT on the blockchain. So the court actually ordered service of proceedings, and as part of that, the court ordered that there would be a hyperlink when the order was made on the NFT, so that when someone clicked on that link, they would track, and it didn't specify this, but I could imagine that it would track things such as, you know, the IP address of the computer from which the link or the click on the link was made. So whether those proceedings were deemed to be served, I guess they are, so the matter can proceed, but whether the defendants will ever come forward and whether they'll actually know who they are, I think has a question mark over it. I mean, there's been cases where the English courts certainly are happy to make orders against unknown persons, and matters can proceed against unknown persons. But, you know, if you're a plaintiff and you get an order against an unknown person, how far does that take you? You know, I think there needs to be a lot of work done trying to find these people before you go spending money getting, I mean, that works if you're just trying to get, you know, things shut down, if you want to get freezing orders and injunctions and things like that to stop things happening. I understand that. But, you know, you certainly wouldn't be making claims against unknown persons just for the sake of it.
Right. Thank you, Allison. we perhaps have time for one more question.
Daniel, may I interrupt then, if I may?
Yes, please.
Thank you very much. One thing that strikes me is that an IP address can be hidden. And you can be in one country, but you can be hiding your IP address behind something else.
Yes.
So to both Luciana and Allison, I mean, how does that affect the evidence and proof and all the rest of it?
And again, any of this evidence, Stephen, is all, as Luciana mentioned, circumstantial. So, you know, there can be a lot of time spent finding IP addresses, but that's exactly right. The IP address could be from a completely different area. I guess the way, though, the clustering heuristics works, though, is that, you know, it does look at it over a period of time. It does look at where it's coming from. So again, it's piecing together the circumstantial evidence to say, well, based on these, you know, it's likely to be this. But, you know, I think that you've got quite a high bar in terms of proving case if you've got to go through that. And really, law enforcement in every country at the moment is probably best placed to, you know, start getting some of the rules around this down pat, because, you know, the cost involved and the number of hours to do these investigations are just huge. And it's interesting to see, particularly from the civil side of things, you know, again, you don't want to be spending money. You probably want to be piggybacking with law enforcement. And, you know, if you've been the victim of a crypto fraud or a theft, then report it, and then, you know, make sure you stay in touch with law enforcement. And then if they're able to piece together and get a successful prosecution, only then would you potentially start your civil claim, because you know who you're going after. Yeah.
Right.
Just brief, Daniel, if I just a very, very brief observation. This emphasises the need for the digital evidence professional to do their job properly, obviously, and it may or may not affect what Lynne said about that proposed conventional electronic evidence, which we developed way back in 2016, and which is also included in the book. But those are side issues. Thank you very much, Daniel.
Thank you, Stephen. So I was about to remark that all our panelists are talking about this increasing, to coin up this term, technicalization, the reliance on experts to try to explicate and extricate electronic evidence. And this trend towards that, where our increasing reliance on experts to make sense of the data that we have, how do we resolve this issue of explosion of technicality, which I think is what concerns me most as an evidence scholar, as this area of the law, which is so fundamental to the entire legal process, becomes increasingly more and more technical. I'm wondering if the panelists could have a quick response to my concerns here for everyone.
What we are doing sorry.
You go, Luciana.
So in the fifth phase of the Inter-Pares project, which we ran until 26 included, the work that we are doing is to teach diplomatics to artificial intelligence tools and to enable them to do the work for us. The labeling that diplomatics developed since the 7th century is extremely useful to artificial intelligence. And we are testing it. First, we have tested it on unidentified parchments. They have been digitized, and then we have run the tool through all the hundreds of thousands of parchments in Italy, and see that the ability to actually recognize any kind of sign for purposes of authentication. And then now we are moving it to all kinds of different, we're doing it in the films of the Red Cross to identify soldiers, but also to identify the authenticity of the cards that were created by hospitals for every soldier. So, I mean, there are ways of accelerating the process, but the important thing is not to take artificial intelligence off the shelf and use it for our purposes. It's to develop artificial intelligence that understand the concepts, both the legal concepts and the diplomatic and archival concepts that we have, and then apply it to do this work of analysis throughout whatever it is that is submitted.
I just wanted to add to that, that I think, you know, we're all becoming experts in our own way. For example, I've been involved in digital evidence probably for 30 years. And when I first started, digital evidence was literally converting paper to images, you know, and using computers for a bit of research. You know, now when I look at lawyers specializing in this area, you know, they probably have some sort of information technology degree. They're trained, that they have actual training, or that they have teams. Some of the, certainly the larger firms would all have teams who are trained and have expertise in dealing with electronic evidence. I think lawyers, I think we're still a long way behind in law schools in teaching, you know, undergrads. There should be more focus on electronic evidence. I still am gobsmacked that here we are in 2022 and we probably don't have a year spent on digital evidence, because we need it. You know, there's still lawyers who come out and really can be, you know, yes, they use a computer to put their assessments in, but, you know, they go into a law firm and they might have a case dealing with a crypto asset fraud. You know, their mates might buy and sell crypto asset, but they're not on top of the law in this area. And, you know, I think we need to get serious about digital evidence. We should have been serious about this a long time ago. But if we get serious now, then that expertise, you know, will slowly develop. It has to. It just has to. Like, we can't afford not to get on top of this.
I would add to that, we have to get more serious, and that's something we've been trying to argue in Edinburgh for the last 25 years as well. Really just about teaching evidence. And with that, I don't mean the law of evidence, and I do not even mean specific forensic subdisciplines, but what William Twining called reasoning with facts. What the new evidence scholarships, like Peter Tillers and these people try to do when the forensic revolution started in the 1980s, 90s. And I see this with my students very often. They really struggle to identify what of all these facts is relevant, what is important, how do I build an argument that convinces someone that something happened. And when we were talking in the DNA context, particularly with police back to the 2000s, one of the big problems was very similar. The labs became overwhelmed because the officer said, test everything. Here's a room, test everything for everything. And the lab said, what do you even mean with that? What does it mean to test everything? You need to give me a hypothesis. And if you have a hypothesis, then you have to find out what has to be the case if that hypothesis is true. And then you have an idea of what is relevant for me to test. And we developed standards, I think, to do this better. And now I look at digital forensics, computer forensics, and we have exactly the same problem. A run-of-the-mill pub fight. Suddenly you have 50 people who recorded all of that of their mobile phones. You seize all the mobile phones, you grab in a digital kiosk, not just the one video clip, but everything that's on there. And then you say, well, we have to test for everything because somewhere there might be a nugget that might just work as exculpation for someone. And it doesn't work now, it didn't work then. So for me, it's a skill of good reasoning with facts, building cases based on facts. That is, I think, at least as important as the forensic subdisciplines. And that is
I totally agree, Burkhard. And I think some of that tends to get lost, that, you know, you have to focus on the facts and the evidence, you know, whatever that might be, and understanding.
I think that the legal profession has been too much reactive and too little proactive. And proactive means it's not enough that you teach. You have to do original research with the students involved. You must be one step ahead. As soon as any technology starts to be tested for anything, you must be on top of it.
Yes.
Right away, and try to establish requirements right away. And so work with these people. That's what Allison was saying, is teamwork, but it's not just teamwork in the office of the lawyer. It's teamwork in the school, in the university, and involve the students and be interdisciplinary and multidisciplinary, because that's what we are seeing now in Inter Pares. I have 200 researchers from something like 20 disciplines in 42 countries. And it's important that it is across cultures, it is across laws, and it is across technology and disciplines. And that's the key, to be the one step ahead. Don't wait that the technology comes out. It's too late. Then you become reactive, as it is happening with blockchain, which is a disaster. They have implemented it in Brazil on the land properties, on the land records. Is a disaster. So, you know,
All right.
let's move.
On the rather disastrous note, jokes aside, thank you to our panelists for the first part of our session for this conference. I think Lynne is no longer with us. She is left for her proceedings. Thanks to Burkhard, to Luciana, and to Allison for their contributions. Thank you, everyone. Let's put our hands together to thank them virtually, of course. Let's reconvene in 5 minutes' time. I have now my time as 4:58 or so 4:59. So let's reconvene at 5:04 for the second part of our proceedings. Thank you very much.
Thanks, Daniel. Thanks, everyone.